The matter before the court is a motion to modify a temporary order in the case in regards to a spousal support order that this court had earlier made. Are you still pursuing your motion to modify at this time, Ms. Thompson?
May it please the court, Mr. Larson is requesting today that the court modify the temporary orders in this matter to change the spousal maintenance so that he not have to pay spousal maintenance anymore moving forward. As the court's aware, temporary orders on July 3rd ordered him to pay $2,500 a month for spousal maintenance, and he was ordered to start paying that on July 1st, 2025. However, the petition was filed on July 1st and a summons was issued on July 8th, and Mr. Larson was not served until after that. So as a preliminary matter, no matter whether or not the court agrees to modify or not, we would ask if the court is inclined to keep spousal maintenance ordered that it state that the maintenance payment not start until August 1st of 2025. So that would allow him to have not missed a payment for July. The main reason, however, that Mr. Larson should not have to pay anything in spousal maintenance is due to the fact that there are four reasons. First, petitioner lists in her expenses in her DRA that she owes or has about $1,245 each month that she has to pay. And she's, of course, requested well above that by about $1,300. And so I believe she has greatly overstated her needs in the request. Second, the petitioner has access to joint banking accounts of the parties that have more than $49,000 in total in them. And this includes a savings account that has at least $34,000 in it. All of that is more than enough for her to utilize to pay her monthly expenses while the matter is ongoing. Third, there's no evidence that petitioner has actively sought a job. Mr. Andrews may make us aware of something different to that when he makes his statement to the court. And I would let the court know that Mr. Larson is now here with me as well.
Hello.
And so we are asking that she not be awarded spousal maintenance because she's more than capable of obtaining a job. And in fact, any job at minimum wage would provide her a monthly income greater than what she lists her expenses at. But fourth and most importantly is this joint investment account that the parties have that receives dividends on a semi-monthly basis. Ms. Larson has claimed in her response to our motion that she didn't have knowledge of the joint investment account, that it received dividends until just very recently. And frankly, this just belies credibility. Ms. Larson, the petitioner, has had full access to that account with her own login and password since the day the account was open. She has authority to move the money in the investment account to a joint banking account to pay for bills. And in fact, this was typically done during the marriage by Mr. Larson. Ms. Larson did not do it because she entrusted the finances to him. However, the money from the dividends was used to pay marital bills. It was used to pay for vacations, for taxes, and for other expenses. And the money was reinvested at one point into some stocks, but that has not been done since 2023. So the fact that she's stating in her motion that she didn't know about this while identifying that the dividends come from Brazilian oil stock doesn't really compute. In fact, it's my understanding that Ms. Larson told Mr. Larson when they were getting a divorce that she wanted the investment account because of the great dividends that it pays. So in the motion, we are asking the court to order her essentially to access that money to use as her monthly income for her expenses, if nothing else, even though there is another source for her in terms of the joint banking accounts. The petitioner also stated in a response that she had just recently found out about this account, but her DRA that was filed on July 1st lists the account and lists a full value of $645,658.07, which is a very specific number for someone who didn't have knowledge of it. So I think that the average monthly income from those dividends, which typically is in the thousands, for last year it averaged about $4,800 a month. And it gets deposited, like I said, 8 times during the year. And so she would have access that she already has to take that dividend money that's coming in, move that over to a joint account or whatever account she wanted to set up for that, and then use that to pay for her expenses and her groceries and anything else that she's listed as her expenses on her DRA. And the argument that this would somehow deplete the marital assets, I just don't think flies, because as the court's aware, spousal maintenance is not a right or an entitlement in Kansas. It's inherently transitional. And when the parties' assets suggest that both have the means to support themselves through their joint assets without spousal maintenance, it's a fair question for this court to ask whether spousal maintenance is even justified at all. In fact, I think it would create a windfall for Ms. Larson to get spousal maintenance, because she would be getting the income monthly that is coming out of my client's paycheck, in addition to what she would eventually recover from the marital estate and when the assets are divided. And so in sense, getting dual payment for those amounts. So for all of those reasons, we don't believe that spousal maintenance is needed or justified in this matter. And we ask that the court order and change the temporary orders so that Mr. Larson is not ordered to pay spousal maintenance.
Before we dive in, drop a comment. Are modern men more delusional, or is it the ladies? Hit like and subscribe so you don't miss what we expose next. Now, let's talk about what's really happening here. It's honestly disturbing that our legal system even allows a setup where a person can walk away from a relationship and still feel entitled to strip their ex of everything he's worked for. Think about it. Decades of hard work, late nights, sacrifices, and in one signature, half of it can disappear. And the mindset behind it, pure extraction. Her focus isn't on healing, rebuilding, or moving forward. It's on squeezing every last dollar out of a man she once claimed to love. But here's where it gets even darker. This isn't just about one woman and one divorce. This is a cultural pattern. Modern relationships have turned into transactions, and the courtroom has become the collection agency. The idea of partnership has been replaced by a mindset of, how much can I take on the way out? And here's the kicker. Greed always comes with a price tag. When the only goal is to drain someone dry, karma has a way of circling back. As you'll see later, the very system that seems to reward this kind of entitlement often ends up teaching the most painful lessons.
Thing in spousal maintenance since the court issued temporary orders.
Yes, he made a payment in August for the $2,500 that was ordered.
All right. Anything else at this time, Ms. Thompson?
No, Your Honor.
All right. Mr. Andrews?
Thank you, Your Honor. Your Honor, I'll attempt to address Ms. Larson's points in order. First, with regard to the expenses, the domestic relations affidavit did contain estimates of the current expenses that Ms. Larson was incurring or was expecting to incur, and that shows that there was only a need of $1,245 a month, which is less than the $2,500. However, those expenses, again, were estimates based on the fact that Ms. Larson is in the marital residence, that she has not been the one who has been responsible for the finances during the parties' relationship. And so she was attempting to make those estimates based on what little information that she was able to gather on her own. However, notably, the expenses do not include a rent expense, for example. Ms. Larson is the parties are going to be selling the marital residence, so Ms. Larson is going to be incurring some form of expense in order to live in her own place. It doesn't have a health insurance expense because she's currently covered under Mr. Larson's health insurance. There are a number of expenses that are not incurred or not included in the DRA because they're just unknown or haven't been incurred yet. On the flip side, Mr. Larson can easily afford to pay the $2,500 a month that we requested. Based on his domestic relations affidavit, it looks like he has a net balance of $20,908 a month after payment of his expenses. We're asking for $2,500 a month to help support his spouse. We believe that it is not inequitable to ask Mr. Larson to support his spouse. They've been married since 2011. This is a relatively long-term marriage. And Ms. Larson has not worked since 2012 by agreement of the parties. She has remained at home. She does not, I mean, to say that it's just easy to go out and find employment with everything that's been going on the last couple months for Ms. Larson's, I don't think that that's fair. When she's been out of the workforce for over a decade, and Mr. Larson has been the sole caretaker financially for her. I don't think that it's fair that Ms. Larson should have to depreciate her half of the marital estate in order to support herself when Mr. Larson has more than enough finances to not only support his spouse, but also to continue to grow his half of that marital estate significantly. Again, as I noted, his income is sizable.
Look, the problem isn't just money, it's mindset. We're dealing with a situation where someone expects lifelong financial servitude simply because a ring existed at one point. Marriage isn't a blank check for entitlement, yet that's exactly how some people treat it. The idea that your past partner automatically owes you everything for the rest of your life, that's not love. That's exploitation disguised as rights. And let's be real, this isn't some sympathetic scenario where he left her for no reason. She made a choice. She walked away. The responsibility for her financial survival doesn't magically transfer to him just because she failed to plan for life outside the marriage. Adults who choose freedom must also accept accountability. This is where society's double standards hit hard. Men are often expected to man up and carry the financial weight of someone else's decisions, while women in similar positions face no equivalent expectation. It's entitlement dressed up in victimhood, and it's a pattern that's growing, one divorce settlement at a time. In short, making a mistake in marriage isn't a lifetime subscription to paying for someone else's lifestyle, period.
With regard to the investment accounts, Ms. Larson was aware that there were investment accounts. She did not know that it was paying out dividends. And I think that was the point I was attempting to make in my response. If that didn't come through, she found out recently about the dividends, but it's not because she actually received them. In fact, Mr. Larson sent a text message through the party's daughter, stating that the dividends are paid out periodically throughout the year. And as he said, I'm quoting here, these dividends were from the Brazilian oil stock that Heather knows about and even said she wanted the stock from it at one point. The dividends we had go back into buying more shares of the stock minus the taxes we owed on the dividends. These amount of dividends last year was $115,656, $57,828 each, $4,819 each month average paid through the year. His theory is that because there was $4,819 each month on average throughout the year last year, even though that money didn't actually go into the party's account, it was either spent on taxes or reinvested, that this is now going to be imputed as an income to Ms. Larson. And again, I'm taking Mr. Larson's own words here. I'm not relying on what Ms. Larson is telling me. So his position is that because there is theoretical income through these dividends, even though Ms. Larson doesn't actually have access to them because they've been reinvested.
Now we're getting into the real mechanics of entitlement versus accountability, and the hypocrisy is deliciously obvious. Here's the core issue. Dividends are legally considered income. That's not a loophole. That's not negotiable. And it doesn't care if it makes someone's financial plan inconvenient. Yet somehow, in the mind of this gold-digging ex, the law itself becomes flexible when it conflicts with her expectations. She wants a free ride, but reality has rules she apparently thinks don't apply to her. And then there's the lawyer angle. Whether he's bending the truth or simply repeating the fantasy she fed him. It's a classic tactic. Exaggerate, misrepresent, and hope the system bends. Meanwhile, she actually has access to those accounts, which means transparency exists. But she's banking on the assumption that nobody will bother connecting the dots. This is exactly the kind of delusion we see all too often in modern divorce culture. A combination of entitlement, selective ignorance, and the audacity to treat law as a suggestion. The story about her sob isn't just a car anecdote, it's a window into a mindset where convenience always trumps responsibility and fantasy masquerades as fact. Reality check. The IRS doesn't negotiate with delusion, and neither should anyone who's watching this unfold.
To the court that your client does have access to those funds and could withdraw those at her discretion.
She doesn't, what I'm saying is she doesn't act. Oh, so in the sense that she has access to the funds that had been in existence prior to the filing of the divorce, yes, in the same way that Mr. Larson has access to those funds. In the sense that she's receiving a check in the mail for these dividends that she can utilize on her own expenses, that is not correct, because there are no dividends being received. The dividends that were received were reinvested, and no dividends have been issued since then to Ms. Larson's knowledge. Now, if they have been issued, they've been issued into an account that she's not accessing, because typically speaking, we ask that the parties not depreciate the marital estate until final orders of the court are issued, including bank accounts, investment accounts, retirement accounts. And so Ms. Larson is not depreciating those marital assets. Instead, she is asking that her expenses be supplemented by Mr. Larson's income, which is significant and has been used to support her as his spouse throughout the entirety of the marriage. This is, in my opinion, a classic example of a situation where spousal support is warranted. When one party has a disproportionate amount of income, the other party either has little income, or in Ms. Larson's case at this point, zero actual income that she could spend that is coming in on a monthly basis. That's what spousal support is for. Again, if the court were to order that she dip into the marital estate to pay for her expenses, we would just ask that that be not taken out of her half of the marital estate. If that's the proposal, they could come out of the full amount, as well as the money that goes back into the estate while this case is pending should be considered as well as increasing the value of the marital estate. Because what really Ms. Thompson is asking is that Ms. Larson reduce the marital estate while Mr. Larson builds up himself a nice little nest egg with the significant amount of income that he's going to be receiving while this case is pending. And we're not asking that he pay hardly any of his disposable income when it comes to this. I mean, it's a little more than 10% of his disposable income, not his gross income, but his disposable income is being requested for spousal support. I just frankly think that the asking to not have to pay anything under these circumstances is frankly ridiculous.
Oh, boo-hoo. Let me play a sad song for you.
Oh, this part is pure poetic justice waiting to happen. First off, you have to give a little credit where it's due. She's found a lawyer who matches her energy, money hungry, opportunistic, and completely unafraid to risk everything for a payday. It's a match made in, well, let's just say a very expensive lesson. The audacity here is something else. This lawyer is so blinded by potential profit that he's willing to jeopardize his career and credibility just to help her drain her ex. That's the kind of short-term thinking that almost always ends up burning people. And don't forget the incentive structure. He gets a cut of whatever he manages to wrest from the ex-husband. It's not loyalty. It's not justice. It's a financial parasite feeding on entitlement. This is the perfect storm of greed meeting greed, and it's a textbook example of how destructive that combination can be. But here's the kicker. Karma is patient. For both of these so-called gold diggers, the very system they're trying to manipulate is going to turn around and bite them. Overreach and deception rarely go unpunished. And in this case, their own avarice is setting them up for a fall so spectacular, it's almost cinematic. This isn't just a divorce story. It's a cultural cautionary tale about entitlement, opportunism, and the perils of thinking you can outsmart reality.
Support this court reducing spousal support on a temporary basis in light of what your client's estimates of actual expenses are at this juncture?
As long as the court is willing to re-increase it once her expenses increase within the next 30 days, when she's no longer able to live at the house that doesn't have a mortgage on it.
Your Honor, may I address that point?
You may.
The parties were asked, specifically Ms. Larson asked to go ahead and put the marital home up for sale. It is not closing anytime soon, so the argument that she's going to be needing rent is just not necessarily, it's something that she's causing of her own accord. So I don't believe that the court should consider that as why she needs spousal maintenance.
And Your Honor, I would just respond briefly that the parties have brokered an agreement through an auctioneer to auction the house, and she has to vacate by September 23rd.
Sorry, my client was not aware of that or informed of that, and so we do not know of the auction.
Well, according to McCurdy Auctioneer, they've been in contact with them and they agreed on a price and they agreed on a date. So unless McCurdy Auctioneer is providing incorrect information,
I think they needed to
that's my
contact your
assessment.
client first, that's all. And so that's why they didn't have a date to give to my client.
All right. Ms. Thompson, anything further to present to the court at this time?
Your Honor, I just would point out that my client's income is sizable, but he doesn't have a specialized degree. And I know that Ms. Larson doesn't have a degree, and so she is just as capable of going out and earning money during this time. And I think the court needs to take that into consideration. And one final point on the health insurance, that's obviously not going to be a concern at all until this divorce is finalized, because we are not asking for her to be removed from the health insurance, and she can't be removed at this point. So I don't believe that should be considered as well. And there is no check that goes out to either party on the dividends. It goes directly into that account, and she has access to that account and should be able to see those deposits.
Very well. Any last words, Mr. Andrews?
I guess I would just make inquiry if Ms. Thomas knows when the last time there was a deposit into that account. I'm sorry, I said Thompson. I meant Thompson. I apologize for.
According to my client, Mr. Larson, there would have been about 2 months ago, and so there should be another one made soon.
And so again, my understanding is the amount 2 months ago was the amount that was reinvested. So there hasn't been
any reinvestment since 2023 in the first quarter of 2023.
That's not what Mr. Larson told his daughter.
Well, then that's what I'm telling the court today at this hearing.
All right. Very well. Thank you, counsel. Appreciate the quality of your arguments here today, and the court has had the opportunity to review the contents of the file in this case and to consider the temporary spousal maintenance order in this case. The court will make the observation that generally speaking, the court looks at the need of one party for spousal maintenance and the other's ability to pay. Here, there's an obvious large disparity in income between the parties. And the court has also considered the fact that the parties do have assets that are at this point liquid enough that could be accessed. However, I do understand Mr. Andrews' argument and agree to a certain extent with it that depleting assets of the marital estate just for purposes of everyday needs does not make sense to this court. Further, the fact that Ms. Larson doesn't have a job at this early juncture in the case shouldn't be surprising. She wasn't working during the term of the marriage, and while the court would look at her employability for long-term spousal maintenance in this case, the court looks at the issue of temporary spousal maintenance as just a question of cash flow. Both parties need cash flow to keep functioning during the pendency of this case. It's intended, as Ms. Thompson recognizes, to be transitional and at this point, temporary. The court looking.
Oh, this is the moment where reality slaps entitlement right in the face. These two financial geniuses were so blinded by greed, they didn't realize they were digging their own graves, literally lying about an account holding over $600,000 while pretending to have no income or liquid assets. Yeah, turns out the law sees through that pretty quickly. Shocker. What they thought was clever manipulation ended up backfiring spectacularly. And here's the irony. Her insatiable desire for more didn't get her more. It got her less. The judge, looking at the bigger picture, saw through the smoke and mirrors. Instead of inflating her payout, the deception actually decreased the support she received. That's a harsh lesson in accountability disguised as courtroom justice. This isn't just a one-off cautionary tale. It's a glaring example of how entitlement, dishonesty, and short-sighted thinking collide in modern divorce culture. When you prioritize immediate gain over integrity, the system, and sometimes just common sense, has a way of recalibrating the score. Lesson learned. You can try to play the victim, stretch the truth, and chase after someone else's wealth, but when reality catches up, the only thing you're left with is regret.